Obviously, as Your Honor has stated, you've gone through the briefs. Just speaking candidly, we had an incredibly large concern based on the interview video that was, or the interview audio that was sent over to us on Friday. That is still of grave concern. But as we have received this, what is our Exhibit 4 investigative report, we had a chance to dive into it last night, very late. I know we emailed the court at 1:30 in the morning, I believe. As we're discussing it today, it's what we would describe as a bombshell. Not just regarding the entire Minot Police Department, but especially the case agent that's sitting here, Detective Asham. She's implicated throughout it. She's implicated for personal reasons, and I do not take any joy in doing this right now, Your Honor. This was hard for us to make decisions on how to do this last night, but this is such a serious case, we have no choice. In going through the report, there are incredibly disturbing details. There's discussion of deleting emails, deleting files. There's recommendations from the firm that went through this that the entire office needs training on Giglio, and I'm summarizing what I've seen, but it goes on to say that lying is part of the daily course of business at the Minot Police Department, on and on. And again, I'm summarizing because I don't want to go through the quotes, which I assume Your Honor has looked over here from that report. But it's an absolute bombshell. Detective Asham is not only the case agent in this case who's on the trial team and sitting through this, she was the lead investigator on this case after Detective Talbot left. And as this comes to light, I'm sitting here on my phone seeing that Rob Port has published this report independent of our filing of it based on a FOIA request he did at I think 12:09 today. It begs the question for me when the state knew about this, when Rob Port got this. I know there were redactions that were done. The fact that it's such a bombshell and it was disclosed to us yesterday, moments before trial. I actually disclosed to us, I know there was the phone call on Sunday saying there's some impeachment evidence regarding Ms. Asham. Honestly, our arguments for dismissal we believe are completely valid on every front, all three arguments. This one we thought was going to be our weakest, and we now believe is absolutely our strongest, based on the incredible things we're reading in this report. And it's a thick report. I know it's 57 pages. It's top to bottom. It's incredible. There's accusations of rape. There's accusations of incredible things. And I know we attached it last night. I know we're moving and grooving, and I don't know how much Your Honor has had a chance to review it. But
I made that clear. I've read it all, so
okay.
We may continue.
I didn't hear you say it, Your Honor. I apologize. But first of all, it would have changed our entire jury selection process to talk to people about police misconduct, how they would judge officers, especially officers that are sitting here, if they lie, if they cheat, if they destroy evidence. Again, in reading this, Detective Asham is the one referenced in our Exhibit 1 with the email chain I have with Ms. Sorgan, that it sounds like it kept the CD in this evidence room or whatever they're calling it. It doesn't sound like it was in the normal course of the evidence file for the Ward County State's Attorney's Office. And then I flip last night and I'm reading that she's texting about destroying emails and files. It's incredible, Your Honor. And I don't know, first of all, I know that the state in one of their prior arguments had talked about a trial by ambush from us based on one of their motions. I can't think of a bigger trial by ambush than what's going on right now. We're getting disclosures regarding the case agent and lead investigator in the case at 7:09 a.m. the morning of trial that blow up the entire police department, that blows up the credibility of their case agent and lead investigator. There is so much work and so much investigation this creates on our behalf that I believe this rises to the level of dismissal. Obviously, we've requested alternate relief in case the court doesn't believe that dismissal should go forward. I'm not going to get into my other arguments regarding the interview with probable cause and the Brady violation. I think they're incredibly important, but I don't want to take up too much of the court's time. I also let the court know in our brief that we did this last night after dinner between then and 1:30 a.m. We were as thorough as we could be. This thing could be 50 pages long, Your Honor. We sat in a hotel room all night putting this together and finally just decided to kill it at 1:30 in the morning. We could have gone until 5 a.m. It's a bombshell on proportions that I cannot describe. I had no idea this was going to happen when we were meeting yesterday. The primary basis for everything we discussed was the Hall interview. As I got into this, I was blown away. I've never seen anything like it in my career. It's the kind of stuff you read about happening in other states. As we speak, articles are being published based on FOIA requests that happened. I don't know when. And I'm just downloading and trying to digest this information. And it's appalling and incredible to me, Your Honor. And I asked that the court on all three motions dismiss this case. I ask if the court doesn't dismiss it, that it grants our alternative relief. But I will end by saying, Your Honor, we have done everything we can in this entire trial. We have done everything we can by the book. We have worked with the state's attorney's office, and we have been hit with discovery right before trial again and again and again, and this is the final blow. This is a sledgehammer. In November, we got information regarding newly investigated bug reports that weren't done prior to charging, right before trial. In February, we got hit with another discovery bomb when my brother was sitting there doing the hearing, when the court closed discovery, I believe, on March 4th. Then we get this interview on Friday. Now we get this investigative report that is an absolute bombshell, and I have never seen anything like it, at 7:09 a.m. on Monday, the week of trial, the day of trial. I have not been able to go through it in the depth I would like to. We were racing to get this done yesterday, and like I said, Your Honor, I'm absolutely appalled. I've seen nothing like this in my life in practicing law. I'm sitting here as we're doing jury selection, watching the news come down, front page, front page, front page, from Rob Port on this FOIA request. My guess is this report's about to go national, and it's not because of me. And I'm concerned about what other disclosures are out there. We got this because Rob Port did a FOIA request, and thank God he did it just in time. This is happening over and over again. It's becoming a course of practice, and it's absolutely blowing this case up. And Nichole's family has spent so much money and so much time on attorneys and travel, expert witnesses that are scheduled to come in this week. This is an absolute abortion of justice, Your Honor. And I don't like to get this way. I'm appalled. I've never seen anything like this. That's all I got.
All right. Thank you very much, Mr. Sand.
Thank you.
Ms. Sorgen, do you wish to reply?
Your Honor, as set forth in the state's papers, I'm not going to reiterate what was put forth in our filings on there, but I will address what Mr. Sand has just indicated. First off, I don't even know who Rob Port is. And so he is not the reason that they received their report. We are. We provided it to them as soon as we got it. Now, Mr. Sand's probably going to take issue with that. This was sent after hours to myself and Mr. Nelson on Friday, after hours, as we were preparing to come here. Mr. Nelson got alerted to it while he was driving on the road on Sunday to come here, called Mr. Sand immediately after that. He called Mr. Sand before he called me. I found out about this after Mr. Sand did, Your Honor. Upon checking this, making sure that we could even get at the email with the Wi-Fi situation, it was then forwarded, which the earliest that could happen was Monday morning at 7 a.m. And my apologies for how that is late, but unfortunately there's no opportunity to have changed that, Your Honor. It was not in our hands until later in the afternoon on the 14th. And again, because of the email and preparing to come here and getting it all together, it got forwarded as expeditiously as I possibly could on that point, Your Honor. As to this February discovery bombshell, I think we established that at that February hearing. It was 2 copies of digital maps that were sent over as part of the Axon transfer with the information. The interview on Friday. I addressed that in our papers, Your Honor. I'm not going to go into that any further. That's information that was available to the defense, could have gotten to the defense had they bothered reviewing their discovery before that and determined that it was an empty file. Could have been done within due diligence, and I addressed that in our response to their allegations on Brady. As to the blowing up the credibility of our case agent, credibility is an issue of the jury, Your Honor. I don't think that this report blows up her credibility. Mr. Sand wants to cross-examine her on that. That's his option. He can do that. I've set forth when the state knew about this report. I can tell you when Mr. Nelson and myself knew about it, and that's exactly when. And I would like to reiterate, Your Honor, that Mr. Sand is arguing that this report implicates Sergeant Asham throughout. Please note, this is a report regarding Lieutenant McLeod. Sergeant Asham is mentioned in it tangentially with regards to a relationship with McLeod and inappropriate behavior on McLeod's part. Information that was contained therein that may pertain to Sergeant Asham, again, that's something that can be either cross-examined on or, as we set forth in our paper, if the court wishes to allow for a pretrial deposition under Camp Rood for the defense, that's permissible, and that's the remedy that's outlined by the North Dakota Supreme Court. The conclusions of that report, Your Honor, again, are in large part due to the behaviors of Lieutenant McLeod. I can't reiterate enough that this report is titled McLeod Complaint Report. It's not the Asham report, as the defense wants to put it in their papers. It is the McLeod report. Thank you.
All right, thank you very much. Time is 3 minutes after 3. The court's going to go off the record. I'm going to take 12 minutes, and then I'll be back. All right, we're back on the record. The time is 17 minutes after 3 o'clock. I took a few more minutes than I told you I would, but it had nothing to do with what I was reviewing. It had to do with another issue. That issue is the court has dismissed, let me find him again here. Which one? Yeah, the court has dismissed juror 44, which is Mr. Eric, for a medical reason. I did that on my own motion. So, as to the motions before the court, Mr. Sand, I very much appreciate your intense argument with regard to the dynamics of this matter. And so I'm going to try and address these on the record. I will follow up my response with a written order that we will follow sometime either today or tomorrow. But this is where we're at. On the failure to disclose the Devin Hall interview, this was an interview that took place back on September 10th of 2008. It took place in Wolf Point, which is, I understand, a town in Montana. This was an interview of Mr. Devin Hall. Devin Hall was a person of interest with regard to this case. It's my understanding that this was a follow-up interview, that a previous interview was done with Mr. Hall while he was incarcerated in the Ward County Jail within 2 weeks of the crime in this case. He was, at that time, specifically a person of interest. He continued to be a person of interest throughout the investigation. It is my understanding that the follow-up interview that was done is the one that's of interest here, and that, if I understand the dynamics correctly, that the defense did have this interview in the sense that it was disclosed by the state, that the file that they disclosed was empty, as was the file that the state had. It then went from that emptiness, once it was discovered, to tracking it down, that it was being held somewhere else in a more solid form than on some kind of digital platform. But it was disclosed back in May of 22, so May 16th of 2022, when it was originally disclosed. I would also note that in a review of the preliminary hearing that the court did, that Attorney Becker, who was part of the team that was representing Ms. Rice, did in his cross-examination of the state's witness for that hearing allude to a re-interview to the officer that took place in Wolf Point approximately about a year after the original interview, which took place again in the summer or early fall of 2007. That would fit the time frame of the interview in Wolf Point in September of 2008. So Mr. Becker did not specifically say that interview or gave a date and time, but he did make reference to the interview being over about a year later than the original interview. So I don't know if it's the same one or if there's a third one somewhere else. That part's not knowledgeable to me. But I do find that the state or that the defense did know about it. The fact that neither the state nor the defense knew that the file that was shared was empty. But again, I find that the defendants or the defense could have obtained that knowledge of it being empty and obtaining the actual interview with reasonable diligence on their part. So that having been said, in finding that conclusion, that would be, I guess, item 2 of the Brady review as to any violation by the state. So on that point, the court will not dismiss this case, nor will there be a remedy for the defense in regard to their motion. As to the second part of their motion, failure to disclose the report that was received by the state based on the information that the court has sometime late last week or over the weekend. This report was the bombshell, as Mr. Sand described it. And then again, he lists this as a Giglio violation, again, that being reference to a particular case. The criteria for that is the same as Brady. It's just that it's expanded it from the evidentiary portion to actual witnesses. That the disclosure of the information that could be used by either party for the purpose of impeaching a witness is now part of that Brady review or the same criteria. In regard to that, the court finds that under number 3 of the Brady review, there was no suppression by the state. Also found that whether or not that information would reasonably change the possible outcome or make a difference, the possibility of a different outcome, the court does not find those as being appropriate in this case. The court would, however, allude to the fact that because that report came late, again, having nothing to do with this trial per se or the people in it, other than, as Ms. Sorgan said, the tangential reference to Officer Asham, the court is inclined to give the state some time, if they wish to do so, to do a deposition of Officer Asham in preparation for her testimony and your ability to cross-examine that. As to count 3, this is the request in regard to there not being sufficient probable cause. Again, this would be with regard to Devin Hall. The court denies that motion aspect also based on the court having reviewed, again, the preliminary hearing information, having reviewed the actual September of 2008 interview of Mr. Hall. The court finds that the outcome of the probable cause hearing, the preliminary hearing, would not have been any different. The information that was shared at that preliminary hearing is not changed or modified or in any way would have affected the court's decision at that time based on the hearing of that September 2008 interview with Mr. Hall. As a matter of fact, the court's thought is that it did nothing in addition. All the information that was shared at the preliminary hearing was sufficient for the court to make its finding, and that additional interview would not have changed that one way or the other. Again, I want to make clear that the court is aware that the current report having been made was specific to a Lieutenant McLeod, who was part of the Minot Police Department. And I will go with Mr. Sand's position that the information in that report is horrible, for lack of a better term. It's disgraceful. It's scary. I get all of that. But again, I don't believe that it is directly causal to this particular case, and I didn't find any connections in the report that would bring it to that level. What I did find is, again, credibility of the possibility of a witness, specifically Officer Asham, if I keep saying that right, I apologize if I don't, but that will be for the purview of the jury. Accordingly, the court will give the state an opportunity to depose Officer Asham. She will make herself available, and the state is required to do that. She will be available from this point forward all the way until 1 o'clock tomorrow. The idea would be, I know you need preparation work to do a deposition. I know you have to somehow schedule a deposition, and I know you will want to perhaps articulate a review once you've done the deposition with regard to her testimony. My understanding is her testimony is not until sometime next week as a possibility, but again, it may also affect that deposition may affect the possibility of other material witnesses in regard who may be a part of the police department. Again,
Can I ask you some clarification?
No, not at this point. The again, I do not believe in my review of that report that you're going to find that information, but then again, that's not my job. So I'll leave that to the defense to do that if they wish. That having been said, the court is still at this time, based on my denial of your motions, going to go forward with the swearing in of the jury today, and we will do opening instructions and opening arguments, and we will take the first two witnesses today. At that point, we will not be in court tomorrow morning. We will start court again at 1 o'clock tomorrow afternoon. Now, Ms. Sorgen, do you have questions?
Yes, Your Honor. You had indicated twice the state could depose Ms. Asham. Did you mean the defense?
No, I meant that the state would make her available. If I said the state would depose her, I apologize. It would be the defense would have the opportunity to depose Officer Asham.
Just double checking,
The state would
Your
make her available.
Yes, we will, Your Honor.
I apologize if I said that. Mr. Sand, other than the look on your face, anything else?
I'm just going to maintain my objections, Your Honor, and I appreciate the court's decision, but I have to maintain my objections. There's a lot more work that this report calls out than just a deposition of one person, and due process is being violated for my client. That's all I have, Your Honor.
Okay. And I do appreciate that, Mr. Sand. And again, that will be your position. It's not the position of the court at this time. All right. Ms. Sorgen, anything else for this hearing?
No, Your Honor.
Mr. Sand?
No, sir.